Good evening. It is Monday, February 8th, 2021. This is the Board of Commissioners meeting. We are streaming live via Zoom, unless of course you're watching a rerun on YouTube. In either case, welcome. We're doing public participation this week as we did at our previous meeting by Zoom. So you will not need to write us an email. Instead, if you have pre-registered, you'll be able to comment as we go in real time. With that said, let's get started with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Moving on to public participation. Is there anyone who would like to give comment at the beginning of the meeting? I'm not seeing any hands raised, so we'll move on to the consent agenda. Are there any items of the consent agenda that any commissioners would like to pull?
Letter C.
So here's C. C as in cat?
C as in cat.
Okay. Hearing none other, let's move to item C, resolution number 2021-10, authorizing the reduction of police officer contributions to their pension plan from 5% to 3% for the calendar year 2021 for officers hired before January 1, 2013. I will so move. Is there a second?
I'll second.
Thank you. Is this going to be Chief you, or is it going to be Bob Tate?
Mr.
Kind of bridges
President,
financial and police.
I can address this one.
Please.
Pennsylvania Act 600, which governs police pensions in the state of Pennsylvania, requires officers to contribute 5% of pay towards their pension. However, that can be negotiated through collective bargaining and can be reduced, which had occurred in Radnor Township back in 2004. And the board had agreed to a contract that reduced the officers' pension contributions to 3%. So while we are legally permitted to do that, the Auditor General's office does require that the municipality adopt by resolution each year to reaffirm that agreement, that reduction in pension contributions for the police officers. And so it's before you tonight for 2021.
Great. Is there any commissioner comment?
Yes, thank you very much, Bob and Bill, for bringing this item up. As Bob indicated, Pennsylvania statute generally requires a 5% contribution by police officers. In 2004, there was negotiated before any of us were on the board, even me as the longest serving board member. It was negotiated to 3%. However, it does need to be voted on. And until a few years ago, this item was never voted on. It was raised upon audit by the state, and it's something that needed to be brought to the board. And I commend Bill White and Bob Tate and Superintendent Flanagan for making sure that it's on the agenda so that it can be voted on. In the past, as I say, it was never voted on. This is a provision that I would never have agreed to in 2004, or if it came in 2013 or 14. So while we may disagree on elements of it, as long as there's a vote as required by the state, and if we're going to deviate from state requirements, it needs to be voted in. So I'm glad that this is raised and we have an opportunity to address this issue based on a negotiated item from 2004. I hope the board will take this and consider it for future collective bargaining, and that a 5% contribution that's required is something that we have considered in the future. I'll also point out, because I know Bill will do it, that officers hired after 2013, this doesn't apply to, and that he'd also say there's changes to the pension and others that have cause cost savings to go to the township, and that is true. This is an older provision, but nonetheless, procedurally, I think it's very important that we vote on it tonight, and glad that it's brought before us. And I think this is the second or third time we've done this since I've been on the board, so I'm glad to see it. That's my comments.
Okay, is there any other commissioner comment? Hearing none, I'll call the vote. All in favor say aye. Aye.
Aye.
All opposed, nay. Motion passes
Nay.
6-1. Moving on to the balance of the consent agenda, I will move for the balance of the consent agenda, items A through B and D through K. Is there a second?
Second.
All in favor say aye.
Aye.
All opposed, nay. The consent agenda items A and B and D through K pass unanimously. Moving to committee reports, number 3A, starting with resolution number 2021-16, recognizing and celebrating the month of February as Black History Month. I will so move. Is there a second?
Second.
Okay, I'm going to read the resolution into the record, and then we can, I guess, have commissioner comment, but hopefully move quickly to a vote. Resolution number 2021-16, a resolution of Radnor Township, Delaware County, Pennsylvania, recognizing and celebrating the month of February as Black History Month. Whereas the contributions of African American citizens as scientists, inventors, farmers, educators, homemakers, and explorers, in addition to countless other professions, have greatly benefited our nation, and whereas Dr. Carter G. Woodson first initiated the recognition of African Americans during the month of February in 1926, when Dr. Woodson set aside a special period in February to recognize the heritage and achievement of African Americans of the United States, and whereas Black History Month was officially recognized in the United States in 1976 as part of the bicentennial celebration, when President Gerald Ford urged Americans to honor the too often neglected accomplishments of Black Americans in every area of endeavor throughout our history, and whereas since 1976, Black History Month has continued to be a month-long celebration of African American history and accomplishments in the United States. Now therefore be it resolved that the Township of Radnor, Delaware County, Pennsylvania, does hereby recognize the contributions of the African American community to our township, our state, and our nation, and encourage all citizens to seek increased awareness and understanding of these contributions. So resolved this 8th day of February, 2021. Is there any commissioner comment? Is there any staff comment? Is there any public comment? Hearing none, I'll call the vote. All in favor, say aye. Aye.
Aye.
All opposed, nay. Motion passes unanimously. Moving on to resolution number 2021-23, our Drawson Farms lot line change plan for lots 3-2, 3-3, 3-4, 3-5, and OS 8A, final, revised final subdivision plan. Ms. Marr, is this yours?
Do you want to make a motion, Jack?
Yeah, sorry, I will so move. Is there a second?
I'll second.
Ms. Marr, is this yours?
Yes, it is.
Now, you've already told us a little bit about this once, but for the sake of those who are joining us for the first time today, could you give us just 2 minutes worth of background on this?
Yes, my husband and I purchased these lots and always had intended to try to keep as much as possible with the natural trees and landscaping, etc., while also trying to build our home in there. We originally thought we were going to build on 3-3, but when the landscape architect and the architects looked at it, they realized that the size of 3-3 was small, such that we would have to take out a significant quantity of very large trees. And that's what I loved about that property, were the large trees. So we originally changed it back probably 2 years ago to make 3-3 larger. And now we are moving it back to make 3-2 larger. So it is not really anything with anyone else other than our lots. The only other thing is that there was open space between lots 3-3 and 3-4 of about 20 feet wide. And we are now taking that open space and moving it to the end of 3-5 so that all of our lots are contiguous. And in doing so, I do believe it actually added a little bit to the open space that was already there.
Okay, excellent. Is there any commissioner comment?
I'll just comment. I met Kathleen out there and she walked me through the plans and their vision. And it's fantastic. They're going to be saving some pretty incredible heritage trees that are part of the view shed that we so treasure over there at our Drawson. So thank you, Kathleen, for having that foresight and that vision. I think it will be an incredible addition and a great way to save those beautiful trees.
Thank you.
Is there any staff comment?
No, Commissioner, this plan is just moving lines on the paper. We have no comments, as you can see by the attached letter from Gannett Fleming. The only thing we're requesting is it be recorded if so approved by the Board of Commissioners.
Is there any public comment? Steve, do you need us to, if we were to approve this, do you need us to approve this with a condition that it be recorded?
No, sir, it's in the solicitor's developers agreement. So
Okay.
all we're asking is for your approval.
Okay, excellent. In that case, I'll call the vote. All in favor, say aye. Aye. All opposed, nay.
Hey,
Motion passes 6-1. Thank you very much, Ms. Marr.
Thank you, Kathleen.
Thank you.
Moving on to item 3D, appointments to boards and commissions. We have 1, 2, 3, 4, 5, 6 appointments for the board's consideration today. I'm going to go one after the other. I will nominate them, ask for a second. We will take comments and then we'll move to a vote. I will move for the appointment of Christopher Mayer to Carrickoff for an unexpired term to end 12/31/22. Is there a second? I see 2 seconds, so we'll take that. Is there any commissioner comment on Mr. Mayer? Is there any staff comment on Mr. Mayer? Is there any public comment on Mr. Mayer? All in favor, say aye. Aye.
Aye.
All opposed, nay. I think that is unanimous. Moving on to Lauren Mulqueen. I will nominate Ms. Mulqueen to Carrickoff for a 4-year term. Is there a second?
Second.
Is there any commissioner comment? Is there any staff comment? Is there any public comment? All in favor, say aye. Aye.
Aye.
All opposed, nay. Motion passes 6 in favor. Commissioner Booker, I guess we'll say not on the dais for purposes of the meeting today. I will nominate Bob DeMicantonio to the Design Review Board for an unexpired term ending December 31st, 2022. Is there a second?
Second.
Second.
Is there any commissioner comment? Is there any staff comment? Is there any public comment? Seeing none, I'll call the vote. All in favor, say aye. Aye. Motion passes 6-0 with Commissioner Booker off the dais. Moving on to Lisa Lopez Carrickoff for Historical and Architectural Review Board for a 5-year term. I will nominate her. Is there a second?
Second.
Is there any commissioner comment? Is there any staff comment? Is there any public comment? Seeing none, I'll call the vote. All in favor, say aye. Aye.
Aye.
All opposed, say nay. Ms. Carrickoff is appointed to the HARB 6-0 with Commissioner Booker off the dais. I will nominate Skip Kunda to the Planning Commission for an unexpired term ending 12/31 of 2022. Is there a second?
Second.
Is there any commissioner comment? Is there any staff comment? Is there any public comment? Hearing none, I'll call the vote. All in favor, say aye. Aye.
Aye.
All opposed, nay. Mr. Kunda is appointed to the Planning Commission for an unexpired term ending 12/31/2022, 6-0 with Commissioner Booker not on the dais. Finally, Christopher Brubaker to the Planning Commission for a full term. I will nominate Mr. Brubaker. Is there a second?
Second.
Second.
Is there any commissioner comment? Is there any staff comment? Is there any public comment? All in favor, say aye. Aye. All opposed, nay. Mr. Brubaker is appointed to the Planning Commission for a full term, 6-0 with Commissioner Booker not on the dais. Moving on to item 3E, authorization of the swearing in of new police officers for Radnor Township Police Department, Richard Boland and Dylan Glenn, after successfully completing the remaining elements of the hiring process since the board's conditional offer of employment at the January 25, 2021 meeting. I will so move. Is there a second? Is there any commissioner comment? Is there any staff comment?
Yeah, just real quickly, under normal circumstances, if we were live in the boardroom, this would be the night we'd have the officers in and the families and do the formal swearing in. So in this virtual setting, we've pivoted to this, this authorization type of vote from the board. However, there's one element with one of the officers that we do not have back yet. We were promised it this morning by 10 a.m. The doctor's office that we're waiting on has not responded. So it's a matter of crossing a T and dotting an I. So we would respectfully request the board to hold on this for 2 more weeks until we're able to make sure that we are completely clear before we authorize the swearing in.
Okay, that's fine with me. So you're asking us to table it?
Table it for tonight, yeah. And again, it's no major issue. It's making sure that we're absolutely clear and crossing all our T's and dotting our I's and that the process is as clean as possible. So we're excited about these 2 candidates. We're excited to bring them to the board at the next meeting. We just want to make sure that we're all set before we do so.
Okay, would you like us to table as to both or just as to the one with the missing medical info?
Let's do both.
Okay.
Just since it is medical information, we'll just keep it
Sure.
generic.
I'll move to table item 3E. Is there a second?
Second.
Second.
All in favor, say aye.
Aye.
All opposed, nay. Motion to table passes unanimously. Item 3F. We have 1 ordinance and 2 resolutions. I'm going to suggest that we start with the ordinance, but discuss, I suspect, all 3 simultaneously, and then we can come back through, have a motion and a second to vote for the following 2 resolutions. So ordinance number 2021-01, introduction. I will so move. Authorizing the current refunding of the Series 2015A and Series 2016 bonds in the aggregate principal amount not to exceed $8.5 million. Is there a second?
Second.
Okay, we're also going to be talking about, but we have not yet moved for, resolution number 2021-21, engaging PFM to provide financial consulting services for the current refunding of the Series 2015A and Series 2016 bonds, and resolution number 2021-22, engaging Koshin O'Connor as bond counsel for the current refunding of the Series 2015A and Series 2016 bonds. Bob Tate, take it away.
Thank you, Mr. President. And I do apologize. Our bond counsel may have trouble getting on the call, but was scheduled to be on for tonight as well. So the ordinance is a straightforward refunding. The 2015A series, which was some new money for the library project, as well as a refunding of 2010 bonds, are part of this refunding, as well as the 2016 series, which was new money for the park and trail projects. Both are callable in June of this year. The projected savings based on the analysis just as of a couple weeks ago, roughly $39,000 per year, $582,000 in the aggregate. And that's all in with the costs for bond counsel and for PFM as our pricing agent. Both have served in previous issuances for the township. Cozen has been engaged as bond counsel for, I believe it's going on 10 years. And PFM has been involved with investment advisor for our pension plan. And then more recently as the pricing agent on the bond issues. And they help to make sure that Radner's getting the best deal on any of these types of transactions. There is a Moody's call set for Wednesday, and this is anticipated to move quickly within the next 45 to 60 days following your approval and final adoption of the ordinance at the next meeting.
Great. Is there any commissioner comment? Is there any additional staff comment? Is there any public comment? Hearing none, I will call the vote on ordinance number 2021-01 only. All in favor say aye.
Aye.
All opposed, nay. Ordinance number 2021-01, I think I saw unanimity, passes 7-0. Moving on to resolution number 2021-21. I will so move. Is there a second?
Second.
Is there any commissioner comment? Is there any staff comment? Is there any public comment? Hearing none, I will call the vote. All in favor say aye. Aye.
Aye.
All opposed, nay. Resolution number 2021-21 passes unanimously. Resolution number 2021-22. I will so move. Is there a second?
Second.
Is there any commissioner comment? Is there any staff comment? Is there any public comment? Hearing none, I will so move. All in favor say aye. Aye.
Aye.
Aye.
All opposed, nay. Motion passes unanimously. Moving on to item 3G, ordinance number 2021-02, introduction. Approving a 3-year lease for the Philadelphia Area Independent School Business Officers Association, Paisboa, for a portion of the Radnor Township Municipal Building consisting of approximately 1,500 square feet. I will so move. Is there a second?
Second.
Bob, is this you or Bill?
I'll lead us in on this one. As you're aware, Paisboa has been a tenant in this building for roughly 8 or 9 years. When they first leased with us, they leased the area of the township building that the administration is now in. And then their book of business expanded a bit, and they hired some additional personnel, which prompted the last amendment, which allowed them to move into the central area on the second floor. The pandemic has changed their business model. They've shrunk down in terms of the number of schools they're representing, and then also the number of in-person meetings that they used to have quite often, which is why they needed the bigger space. Along with they have more staff members working remotely, and they've told us that that's going to be the way they operate for the foreseeable future. So the space that they once needed, they no longer need. So they came to us asking if we would be willing to swap back the space that as it was under the original lease, where they would come back into the administration area, and then the administration would move back to that central area at the top of the second floor stairs. So this amendment in front of you tonight for introduction would do that. The square footage is approximately 1,500. The pricing per square foot has remained the same. In fact, under the current lease, which we are nearing the end of year 1 of 3, that this would replace, there was a price escalator that was due to go into effect June 1. We moved that up to March 1. So the price per square foot's going up by 1.5%, and they'll pay that rate for year 1, and then the same escalators are built into years 2 and 3. So that's why this is back in front of the board after a year, and what they've reached out for us for.
Is there any commissioner comment?
I have some questions. Bill, so how many square feet is the current office now?
That they're leasing?
Yeah.
I'm going to say 2,700 plus or minus.
So 2,700, and then they're gonna lose 1,500. So we're down to now 1,200 is what they're gonna just run out now.
I think the space that we're in now is about 1,500. That's the difference in space.
It's a difference in space. Okay. So then I'm confused. That area that's being rented when you walk up the stairs, that's whatever that company is.
Yeah,
They want to, and that area is 2,700 feet. Am I correct?
Yeah, it's 2,730 square feet.
Okay, so we'll round it to 2,700. They're saying that is now too big because of COVID. We only need 1,200 square feet. Am I correct?
They're asking for, well, I mean, the way the building's laid out, this area over here is 1,500 square feet. So they'd be going from 27 down to 1,500.
Okay. And what are we going to do with that space once we get it back?
Well, the administration would move back in over there.
Okay. So are we cramped for space or not?
No, I mean, in fact, this would give the administration and more space to give our offices. We would have more offices to not fill up. So,
Okay. So
there's no plans to fill those.
Sure. So is it possible that we could sublet that 1,500 instead or not? Or not sublet it, but could they sublet it, or could we rent that out instead of just moving our staff back in there?
No, because the administration needs offices to operate from. So we need the space. So Paisboa would be on this wing of the building, and they'd be using all 1,500 square feet down here. And then the administration would be moving back into the larger area. And the way it's configured, it's hard to sublet individual offices. It's all one suite.
Okay, I just didn't know, if they do that sharing stuff and whatnot. Okay, all right, those are my questions.
Bill, how much is it going to cost to move back to the space that we had all you folks move out of a few years ago?
The physical cost of moving?
Yeah, there's construction, there's painting, renovation, carpets, moving expenses, computers, yes. Administrative, I don't know, what's the cost? Yeah,
so we're not anticipating any hard costs. The Public Works Department, they were the ones that did the physical moving before. The IT network is already set up because we're returning back to the same situation that existed from roughly 2012 till 2017. So it's just a matter of moving, filing cabinets, files, computers. We're not buying anything more. There's no construction, no walls are coming up or going down. And to the extent walls need to be repainted in that area, again, that's something that the Public Works Department has done historically throughout this building.
Well, there's still that time and opportunity time.
Sure.
I guess so. It sounds like you're going to move back to the old space, and for that, Paisboa is going to pay 1.5% more a few months earlier than the scheduled contract currently in place.
Yeah, 1.5% more per square foot. I mean, it's less square footage. So the rent income to the township will be going down.
Ah, the rent income will be going down, so it's not even an increase.
No, no. Yeah, they're not going to pay the same price for, 2,000 less square feet. Or I'm sorry, 1,200 less square feet.
And so why wouldn't we maintain the current lease until it expires?
Well, for fear of losing the entire tenant. And I should have said at the outset, I mean, Paisboa has been a fantastic tenant. They're easy to work with and to to share space with. So we have a very good relationship with them. Our building and the traffic that it generates under normal circumstances, there's no interference. So they really are an ideal tenant. And given, where they're at as an organization, we're concerned that we'd lose them entirely and have, lose the whole amount of rental income.
So if they walked from the current lease with no changes, what would be the default remedies under the current lease?
Yeah, there's a 60-day termination period. So they could provide notice and move out in 60 days or sooner. They'd owe us 2 months worth of rent, but they could, that's how quickly it could terminate.
Yeah, but it's not likely they would do that. They have to have some space to operate in.
Granted, I just, I'm just not sure I'm not sure how long they would be willing to overpay for space they no longer need. That's the concern.
Well, I would just characterize it differently. It's how long are you going to maintain and live up to the commitments that you've made? I mean, that's what it is. Okay, I guess so you're not planning on any new walls, any drywall or anything, but we will have a lot of staff time and several days to affect this move. So to me, it sounds like it's a pretty significant thing for at least the staff to undertake it. So I would just ask, isn't there any way you could maintain the current rent for the 3 years? Why would we it's one thing to say, fine, take less, and then afterwards we'll reduce it, but I don't know. It seems like you're being awful nice here, and I don't know if we would see this in regular circumstances. This rent does go to pay bonds, so we kind of need this money.
Well, I don't disagree with that, but the agreement that we have with them is specific to the space that they're in. It identifies the 2,730 square feet and identifies it specifically within the building. So, as long as they're in that space, they would have to pay that amount. But it wouldn't take them long to find other space and move out entirely. And then the township's out the 30-some thousand we will get under this revised lease.
But there was no discussion on, at least through the term of the lease. So what's the total dollar figure that's a reduction to the township?
Effective March, assuming a March 1, 2021 effective date, this would, the township will realize about just a shade under 79,000 less in income. So we would have received 175 or 176,000. Now we'll receive just a shade under 97,000. So we're still getting 97,000, but it is a reduction.
Okay, is there any additional commissioner comment?
I have a comment. I have a question. So, Bill, you said that the staff is going to then move in there. Is there going to be any consideration about additional spacing between desks during the COVID protocols? Is this going to benefit the staff by having more space so that they can sit farther apart? How are you building that out?
Yeah, so the space that we'd be going into has a little, I mean, there will definitely be more space between where Peggy sits and where Molly is at. There'll be separate offices, so they would be, everyone would be contained in a space. Peggy's desk is still open air. It's got, it's a desk similar to the one she's in now, just a little bit bigger. But there would be myself, Molly, Peggy, and then the consideration of potentially the treasurer moving back over into that suite where they were prior to the whole swap a couple years ago with Paisboa. And each of those individuals would have their own office, so that they'd have walls and be contained. So pandemic wise, it's pretty ideal. And space wise, I mean, it's just more space. So there naturally more area in between folks. I'm trying to I wish I had a visual, but compare it to a different area in the building, but I'm having trouble off the top of my head. Well, this is up for introduction tonight since it is a lease of township owned real estate. So it'll be back in front of the board in 2 weeks. I can, between now and then, share that with the board, the layout and what that'll look like.
Bill, sorry. Would you consider trying to find another tenant altogether?
For that space?
Yeah. I mean, it's a sizable amount. I'm not saying that you want to kick these people out, but say, look, you can stay here for as long as you can, but in the meantime, we're taking a pretty big haircut. We don't want to lose you as a tenant. But if we can rent the full space, that's our intentions, and we'll give you 3 months to vacate. I understand that's a risk because I'm pretty sure that office space is probably going to be pretty relatively available now with COVID. But at the same time, that gives us a little bit of some options as well. So that's kind of where I'm at. Like, I hear you. I don't necessarily think that we could get it rented, but I think that we need to keep our options open and to work with them. But to say, hey, come next month, we're just giving in. We're going to give whatever you want. I think that there should be a little bit more flexibility on their part and some flexibility on our part as well.
I'm not sure I agree with the characterization that we're just giving in and giving them what they want. The way the building's laid out is ideal for their needs and ours. And in fact, it was exactly the way it was 2.5 years ago. We're just returning back to that setup. And in terms of, actively selling out space in the building, we've never put the space on the market. The Paisboa arrangement was not something that came out of a larger advertisement of space, and we could always do that.
I guess, I would certainly be concerned about the idea. I mean, I think there's certainly a glut of office space on the market right now. Definitely people are trending away from being in offices for the reasons I think Commissioner Mulroney was pointing out. I would hate to cut off our nose to spite our face and then have no income at all. But certainly, I guess if the opportunity arose, we do have a clause in here where we could certainly say to them, were able to find somebody to lease this full space if that came up, and then you just move back where you were, Bill, and we put somebody in the bigger space and we tell them, sorry, we're exercising our opportunity to opt out of the lease. I guess my question is kind of back to something that Commissioner Mulroney was touching on. Are we hiring the new Act 511 person, and then also the person, the new engineer, assistant, engineer? Is this having this larger space? Was there somewhere for that Act 511 person to go into? Will this give more space for somebody else? Like you said, the treasurer to move into your space, and then the Act 511 person can be in the finance suite. And similarly, is there going to be space where, the engineering team is right now to put somebody in there, or will that open up space for those positions?
Yeah, so the engineering person will be down in that department on the main floor of the building. And then in terms of the finance department, if you recall, or if you can envision that hallway down to finance, there's the two gates, the two windows. And again, we haven't had these conversations yet internally, but we wanted to see how this went tonight. But the one gate could be the Act 511 gate, and the other one be the finance gate, and that's where that person would sit. Remembering that the replacement of the Act 511, or the filling of that position, is through the trickle down of all the positions that changed last year, is filling a vacant seat already. So there is the space there, and actually that is pretty ideal for the finance department to have both those windows, one for Act 511 and one for all other township business. And then, quite honestly, I mean, selfishly, in terms of having meetings someday when we're having in-person meetings again, for those of us that have met here in this admin area, it's difficult sometimes to have a full conversation with an open door and folks, sitting in that vicinity. It's awkward for those in the meeting and awkward for those trying to do their work at their desks. So, that's resolved. And again, that's not the end all be all, but, while we're thinking about this and analyzing the pros and cons, that's definitely something that going back over to that suite will allow to have a little bit more separation between people working and meetings being had. But going back to your original question, the finance department has the seats, and the Act 511 person will be down with them, and engineering will be with the engineering department, regardless of this ordinance.
Okay.
Last call. Any commissioner comment? Hearing none, is there any staff comment? Is there any public comment? Hearing none, I will call the vote. All in favor say aye. Aye.
Aye.
All opposed, nay.
Nay.
Motion passes 5-2. Moving on to item 3H. Resolution number 2021-24, engaging Cohen Law Firm to assist the township in a review of local ordinances as they pertain to cellular coverage, facility installation, location, maintenance, and other recommendations as needed at an estimated cost of $7,500. John, is this you? Bill?
I'll tee it up.
Who
And
to talk
then,
about this?
yeah, John's.
Wait, do you need a
John's-
second?
Oh, I'll take a second. Thank you.
I'll tee it up, and then if I miss anything, John, please jump in. But in the last year, I have been involved in quite a few different conversations regarding these micro cell facilities, of which we have somewhere between 15 and 20 in the township right now. There was an agreement that the township entered into back in 2008-ish with Crown Castle on the installation of these and a revenue sharing deal. There have been several changes at the federal level in terms of how much authority municipalities have in controlling this type of activity. In fact, and at the same time, as the commissioners are aware, we have neighborhoods where cell coverage is limited and there is interest in additional cell coverage that these microcells might be ideal for. And then at the same time, we have other residents that are concerned about the facilities and the waves and the radiation that they emit and what that might be causing, good, bad, or indifferent. So we have folks that are very much on two different sides of the issue. John Rice and I have been talking, as we've had meetings with both the neighborhoods who are in favor and want additional coverage and those that are struggling either with sites that are located near their home or just with the whole concept in general, especially with the 5G conversation or the 5G network getting up and running. So John Rice and I had talked on several occasions about Township. How much authority do we have? We have this agreement with Crown Castle. These facilities are located in the right of way, something that we control. And where we're at with it now is, bringing Cohen to the table. They are the experts in telecommunication and legal issues dealing with telecommunication. So being that we're in a situation where we've got two different groups of folks in an ever-changing environment with lots of legal nuances, it seemed that bringing these folks in to kind of help guide the conversation for us as a township made sense. They did a very preliminary review of our existing telecommunication ordinance and had some concerns, which, it makes sense. I think the last time the ordinance was adopted was in the late 90s, and you can imagine how things have changed over the last 20 plus years in that arena. So it would seem to make sense for a refresh on that area of our code anyway. So what we'd be paying for here is for the Cohen Law Firm to come in and advise the township on what they think or what they would recommend be in our books legally in terms of what we're allowed to do and what we're not allowed to do as a municipality and controlling the location, the design, the various decisions that go into where and what these things look like throughout town. Is having a law firm that is an expert in this arena helping guide that conversation. So that's why we're bringing this in front of the board tonight. This will take a little while. There'll be several conversations with the board. Ultimately, the representative from Cohen will, be able to instruct the board on, where you can go, where you can't go, and everywhere in between. And at the end of it, the deliverable will be an ordinance, a replacement ordinance for our telecommunication code, along with design guidelines for consideration when new sites are presented or proposed for the township.
Just one other bit of information that sort of changed the landscape. In July of 2020, the Pennsylvania Supreme Court rendered a decision involving Crown Castle, which essentially said that DAS systems, distributed antenna systems, or also called mini cell towers, were considered a public utility. And outside of the control, much of the controls that we normally would have under zoning. So, and it's regulated by the PUC. So instead of having any kind of local regulation of these facilities, because of the Supreme Court decision, and the different township officials groups fought this, some cities fought this, but basically these facilities now can be issued a certificate of public convenience, just like PICO, Aqua, public utilities that the PUC regulates, which means they're exempt from local zoning to a large extent, and they have the power of eminent domain. So that really changed the landscape, and that's just this past year in July of 2020. Dan's been involved in this. He and I have talked about it on more than one occasion. Various municipalities are putting together some ways to deal with this, but this is a significant issue for the township. A lot of the poles are already up in the township, so it's not an issue as to some of the more rural municipalities are really struggling with this. But I think Dan's, he's been on the front line of this for a long, long time. So that's something that hopefully will come out of this. I think it should come out of this. And then we'll end up with something that's on the books, a cell ordinance, which is up to date. We have some regulation now because of rights of way, but it's unclear to me how far we can go with that. So that's something we'll be, if the board approves this, Bill and I will be working on together with Dan.
Great. Is there any commissioner comment?
Yeah, just a couple questions. I apologize. I had to step away for a second there. So what is precipitating this being brought before us right now, Bill? I know you said that there's, differing opinions in the township, but are there specific projects, specific installations, specific plans that are driving the need for this today?
Well, I mean, as we sit here now, there are neighborhoods that would like additional cell coverage through these micro cells or small cells. And there are some that there are residents that are concerned about existing ones and, want to make sure that the township has the proper codes to, do what it needs to manage this going forward. So why it's coming from you now is, I mean, there's active interest on both sides of this.
But those have been active for several years, though.
Granted, but
Rich, the township has had complaints from residents about existing utilities on poles, and there's some fear about the power that comes off the poles. I mean, there is some health risk depending on separation distance from poles. So there's been a couple of those instances that have come up over the last year, but this Pennsylvania Supreme Court case by itself is enough to take a look at this, because this basically guts your local zoning on this issue. It's something that Bill and I have talked about in the context of different residents' issues and complaints, and there have been a few complaints about existing facilities. And then what's the level of coverage that you're going to see going forward? Because these mini cell towers, like the big cell towers, only have so much coverage. There's only so many calls that can be transacted on a particular antenna. So, and the FCC is favoring this industry. The PUC now, it appears to me, is favoring this industry. And we're trying to get ahead of it. I don't know that there's anything other than we have an outdated ordinance, and there's a lot of things going on around Radnor Township that we're going to need to deal with going forward. And I think, Dan's office, his folks do a good job dealing with utilities in this context.
All right. My recollection was that there was pending legislation last year, or was it the year before, that basically would have said the townships have no right to basically regulate or collect fees on these types of installations. Did that legislation pass or go through, or did that die and the Supreme Court took up where that left off?
No, the Supreme Court case had to do with the current law and the current definition of public utility and the PUC. I know there's been a couple different efforts in the legislature to deal with this issue. Nothing has, what you just described, that hasn't happened.
Okay.
You know, but
What would
it's
happen if we do nothing? Doesn't it give us more flexibility to do nothing so that we can, if we don't change it, then that gives us more flexibility in interpretation, doesn't it?
No.
That's not.
No, that would be ridiculous to do that. I mean, you want to control your own destiny in this area as much as you can. You know, the fact that the PUC has decided that these are public utilities really gives them a blanket of protection from the township's ability, all townships' ability to regulate. I'll give you an example, Rich. There's a municipality in Bucks County that had no sidewalks and utilities were underground. And a DAS operator came along and started putting poles in people's front yards. It was in the right of way, but you know, the right of way extends outside the paved portion of a road. So what people thought was their front yards, utility came along and said, we're a public utility. One of these DAS operators, it wasn't Crown, and started putting poles in there. And that ended up in federal court, got resolved. And that was probably 5 or 6 years ago. So this issue of what these operators can do and can't do has now been settled under this Pennsylvania Supreme Court case. So that's the risk. If you do nothing, that's the risk that you get a call some morning from a constituent saying that someone's putting a pole in my front yard. And what are you going to do?
I thought you just said that basically so what are we going to do about it? What is the goal of this to accomplish in light of the severe limitations imposed by the Pennsylvania Supreme Court on what we can do?
Well, I think that's why you engage an expert, so he can tell you what you can do, what you can't do, what's still up in the air. I mean, I don't know the answer to that. That's why you update ordinances as a result of court cases and legislation. You want to stay ahead of potential problems. And there may be some things we can't do anything about.
John, can I ask a couple questions? So we're going to start with $75 just for the, I guess, investigation aspect to this. What's this looking to cost by the time we're done with the new ordinance?
Well, I think the 7,500 is a number not to exceed, right, Bill?
Yeah, so the 75 includes at the end of it, the board will have an ordinance for consideration. Okay, and getting to Commissioner Booker's point, I mean, if this is an eminent domain issue, what rights do we have? I know people that live in is it Round Hill? I know one person in particular moved in because he liked the idea that there were no above ground utilities. Now they're going to put a pole in their yard that could well hurt his property value. There's no recourse for that. Am I correct?
I mean, that's a pretty general question and set of facts. If part of his lawn is in the public right of way, and the township doesn't have anything in the right of way ordinance that would slow that down, it's a public utility issue. What you do when someone wants to do something under the public utility, you can file a complaint with the public utility.
No.
So that's your remedy. It's not a township remedy stunt. You have to go to the Public Utility Commission and contest that. But you wouldn't have a single pole that somebody would want to put in somebody's lawn, Sean. That's just not, a realistic possibility. You would have 20 or 30 of them along a street.
Yeah, yeah. Well,
What-
I'm talking one person individually. They would have a pole in their yard because
Yeah.
Well,
they
that
put-
has happened. That has happened in my
Yeah,
neighborhood.
yeah.
And that is, I mean, we have residents who have a huge concern about that, who now have poles that are triangulated
Yes.
because there's no, it seems as if there's nobody talking to anyone or any specific way to corral the requests for these coming in.
Sure. So the other question I have is, for instance, in Garrett Hill, a lot of people have telephone poles and electrical wires running in their backyards, myself included. So will they have the right to put it in a backyard, go through somebody's property to erect it or put it on a pole? And then could another company go in the front yard and do that as well? So you're going to be bombarded.
I mean, I think that's all possible. Somebody owns those poles, right? Pico probably.
Yeah.
Pico has side deals with the other utilities. Pico lets them hang their stuff on the poles. So, you know, anytime you have a public utility involved, you know, they have broad powers that are only dealt with by the Public Utility Commission. That's your remedy. It's not going to be a township zoning permit or zoning ordinance. It's going to be going to the Public Utility Commission to deal with some issues. I think because Radnor's fairly well developed and has a lot of poles, that you're not going to have a whole lot of new installed. But, you know, I don't know. As technology changes,
Sure.
I mean, all of that might change along with it.
Sure. And one more question, and Bill, you can help me out with this. In Old Oaks, we had a problem with Verizon. The cables were down for months at a time. You know, and again, that's dealing with a utility or something that is well beyond the scope of the township, as you and I knew and found out, despite our many calls and hearing those grievances. It just seems to me that, you know, stuff like this would have to go in this plan, because it just feels to me that the little guy, the homeowner, is going to get squeezed out by the public utility companies. And I'll just say this, I'll add one more comment about dealing with public utility companies. One of the reasons why I don't want to sell the sewer, because I think that it puts you behind the 8 ball with this stuff, and I don't want to be subject to being a little guy in that situation. So those are my questions, my comments. Thanks.
Just one quick one. Today, under the current ordinance, what ability do we have to impose fees or regulate through permitting the installation of these units? Can we get fees? Can we impose a tax? Can we require a building permit, or none of that under the current code?
Well, Rich, you know, in order to answer all those questions, I'd have to take a look at it, but I think we issue building permits at least. And we have some regulations for cell towers, the big cell towers. I think there's a special exception required. You know, I don't know where that stands now. I think probably the big cell towers, you can still require that special exception. But we would issue building permits, probably electrical permits for these facilities. Sometimes there's buildings, equipment buildings and things like that. So, you know, this is more of an issue of where can they go? You know, can they go wherever they want to go, or zoning usually tells you where certain things are permitted and not permitted. The PUC.
But right now, if somebody puts up a micro tower, we wouldn't know about it, or we would know about it. A micro cell.
Yeah, I don't know whether they're coming in for permits. I know there's an old agreement, Bill, you said with Crown Castle for
Yeah,
certain installations that they have the right to install them. We get a fee. It's been in for a while.
Yeah, like this entire topic, I'm learning as we have this discussion, unaware of exactly what the Supreme Court decided last summer, but you know, the last microcell that we're aware of that where permits were pulled was roughly 2009, 2010. They did pull permits. It was not Crown Castle. It was a different company. But the Crown Castle ones, under the agreement, they are required to submit all the necessary permits to the township. And then there is a revenue share. Again, I don't know if this new legislation or this new legislation from the Supreme Court is going to change that. It sounds like it probably would. But so this discussion is an example of the calls that we're getting on a regular basis or have over the last year regarding these microcells, and are the reason why having Cohen come in and do a full review of this with all of us, I think makes a lot of sense.
So I have residents who have, so a pole was put on their yard. We investigated, the township, we investigated, finally were able to find out who, through a lot of work, not through anything because they came to us and we have documentation, like through a lot of other outside work being done to find out who has these poles. We found out that there's these 2 of them. They have cells on them that have several different carriers going through them. I will say Crown Castle was very helpful and responsive in coming out and dealing with some of those issues, but it would appear there are poles being put up that the town, that they don't seem to feel they need to come to the township to ask for this to happen. And then you've basically got poles within 100 yards of each other, and also basically right in people's front yards. So the example that John gives is already happening, and obviously our ordinance in some way is probably not tight enough, or it needs to be adjusted in some way, so that at least the township has, and again, with the Supreme Court ruling, who knows, but that at least the township has a little more awareness and a say. Can we put forth some things that require certain setbacks from homes and things like that? Once they're up, you can't ask them to move them, and they really won't move them, it would appear. We've asked about that. So I think that, to have someone take a look at, someone with the expertise to take a look at what we currently have and see how, we can protect our residents moving forward. And the residents that I have that are concerned about this have very serious concerns, health related, and also the fact that no one, in no way was anyone consulted, and certainly not the township, when at least one of the poles went up. So, I would be willing to invest in it. I would ask that if we are going to go forward with this, that we put some sort of timeline on this for Cohen. I realized that the Comcast agreement that we just had with them was certainly probably difficult and tricky, but I'm going to say that probably took 6 years to come through, and we don't have 6 years. And I would prefer that, if we are going to give it to them, that we put forth some sort of timeline, that we ask for certain milestones that they meet with regards to getting back to us, bringing forth, we've reviewed, here's what we recommend, and now we're going to write, or something like that, so that it is going to move forward and we have some control over that timeline.
And I agree with all that. Makes all sense. It sounds to me though, John and Bill, that by having Cohen review this, that we might be conforming our ordinance to the law, which might give us less ability to regulate in the way that Lisa suggests. And I'm wondering, is that true or is that not the case?
Well, we can't take any more ability than we're given under the law.
That goes without saying, Jack.
Usually you try to conform your ordinances to the law. So, there's usually also some areas where maybe the law doesn't address that would give us some ability to have some control. I mean, I think that if we get into a battle with an operator, it's going to be in front of the PUC. It's not going to be on a permit by permit basis.
I
So
understood. I'm just trying to get a general direction. I hear Lisa and others and Bill intimated that we want the ability to have greater ability to regulate. And it sounds as if Cohen's going to be doing an ordinance that would codify the Supreme Court's ruling that there's lesser ability to regulate on the part of the township. Is that true?
Yeah,
No.
no, from my perspective, I'm aiming for education and making sure that the township is fully covered and prepared for this discussion moving forward. So that's where I'm coming from a very non-legal perspective. I would think that as part of what Cohen's proposing here is that they would come and have a discussion with the board on all of these issues. And if there is leeway within whatever can be codified, Cohen will they'll define the bandwidth that you have to be within, and then the board can make those decisions from there. I mean, I don't, without knowing the full scope of the law, I don't know how thick that bandwidth might be. It sounds like it might be pretty narrow, but that's my understanding of how this engagement would go.
Okay, we've talked about this for quite a while.
Hey, Jack, sorry, just a couple comments. I don't think anybody's researched and looked at this issue more than I have over the last 3 years. So just a few points to talk about.
Okay, a reminder to everyone, this is $7,500, but
yeah,
go nuts.
I'll go crazy. So Lisa, I'm just trying to get a sense here. The pole in your yard, is that Earl's Lane?
So this is a pole on Earl's Lane and a pole on Malin.
Okay. Yeah, I mean, I talked about these, I mean, there's 18 in the township, and I talked about these, as early as 2018 with the list. So I understand your concerns with new poles going up, but this information is out there. So I'm not sure how we get that to the neighbors, but it's available.
I don't understand your point. So we've been through a whole process with the neighbors on this, and Crown Castle has been in. We've had
I'm just saying, like, if people want to know where these microcells are, there's a list that's available. On the issue of Round Hill, just so the Round Hill residents are who weren't at the meeting are clear, there was first there was no recommendation for 30 poles in the neighborhood, and there was no recommendation for new poles. The proposal that was laid out would be microcells on existing poles that were there, and it would be 3 to 4. There's a 1,000-foot line of sight, and the company was confident that that neighborhood would be covered with 3 to 4 cells, and that's what was proposed to that neighborhood. So the residents, if they have questions, they can reach out to me, but that information is available, and I believe it's online on the township website. For John and Bill, the Cohen group, how many of these investigations and ordinance changes have they done in the last 5 years?
I would probably say it's in the hundreds, knowing what he does.
Yeah, so why 30 hours?
I don't know.
Isn't that a not to exceed? Is the 30 hours part of the not to exceed, the 7,500?
Yeah,
I mean, he might be adding some hours in there, because I was harping on the education piece. So he's probably anticipating some hours in discussions similar to this, where we're hashing out different views and points.
Yeah, I mean, Bill, I think that's actually the key point, is the education side of it, and probably more beneficial if we use that time for Mr. Cohen to educate residents on what the current status of this industry is. And I'm interested to see what he comes up with. My concern is that whatever he proposes, how long until it's outdated? I'm talking to another company right now where, I mean, they're well beyond the concerns of what residents are raising here.
Yeah, I mean, that's fair enough. And that's a good question for Dan when we get this going, if the board approves this.
Okay, and my other concern is, whatever is proposed and if enacted upon, what are we setting residents up for litigation? So if a DAS system is proposed by a company or a carrier and it's opposed at the township level, I mean, the only recourse, and it's been done in the past, is to take that to litigation, and the carriers tend to win these battles.
Yeah, but there's no resident litigation involved. I mean, what Dan Cohen is going to do is make recommendations to the township's current ordinances to deal with this evolving technology. So it's going to be the ball's in the township's court in terms of litigation. If there's something that we have on the books as a result of this consultation that some carrier decides, they want to fight us about, the fight's going to be with us. It's not going to be with residents. And he's my experience with Cohen, and I've known him for probably 15 to 20 years. And he's all over the state. He's all over the Eastern Coast. His office is in Pittsburgh. So, I thought the price was pretty reasonable. I think we do need a time limit. This needs to be done within 90 days or whatever the time limit is, whatever. Bill, you've been talking to him, so I don't know whether you've discussed that, but, he's on the front line. He's in federal court with these cases. So I don't know. I don't see any litigation with residents, Jake. I don't know how that would happen unless they stepped in it on their own, because it's going to be the township's ordinance that will be an issue.
Okay. Well, I'm not sure. Does the township want to battle the utility companies? If what you're saying is that there's, we have little authority.
A lot less authority than we did prior to the Supreme Court case.
Okay.
But that's why, you're asking the questions that you need to ask Dan Cohen.
Got it. All right. Thanks, John.
Okay.
Okay, is there any additional commissioner comment? He said hopefully. Hearing none, is there any staff comment? Is there any public comment? I'll call the vote. All in favor say aye. Aye. All opposed, nay. I think that is 6-1. Moving on to item 3I, ordinance number 2021-03, introduction, amending Article 19, density modification of the Radnor Township zoning ordinance by increasing the required open space for such uses and amending section 280-115 by establishing an open space requirement for other residential uses.
Commissioner Luck, I have a hand raised from one of the attendees, D. Brune, for the last item.
For the last item. Okay, let me go back and allow him to talk for the Cohen Law Firm. Mr. Brune, do you have a comment on resolution number 2021-24? I apologize, I did not see your hand. Mr. Brune. Mr. Brune. Ian, am I doing something wrong here?
No, he's allowed to talk and his mic is unmuted. So I'm not
Okay.
sure. Might be something on his end.
Okay, well, Mr. Brune, we're going to have an additional public comment period at the end. So if you're able to hear me, but are for whatever reason unable to be heard by us, I'm going to suggest that we circle back to you when we get to the final public comment hearing period. Not really sure what else to do under these circumstances. So I apologize. We will come back to you.
You know what, that might be one of the residents who lives down on Mailer Road. I'm not sure. That might be, but
Okay.
I don't know.
Hey, Jack, on that vote, who's the vote in opposition?
I thought that was Commissioner Booker.
Okay, all right, I didn't see it. Thank you.
Not a problem. Back to ordinance number 2021-03. John Rice, do you want to tell us a little bit about this?
Yes. This is a proposal that it came from, I guess, primarily Lisa and Jack to some extent, to address the common open space requirements for density modification and for other uses. So what I ended up doing was taking some information regarding that and then plugging that into this proposal. And it basically does two things. It amends the common open space provisions for density modification to provide for a larger area of the tract. And it also carves out buffer yards, floodplains, wetlands, and some part of the stormwater management. And then the second part of this adds an open space requirement for certain, what I would consider residential uses, but they are things like continuing care, memory care. Our ordinance is a little bit outdated, calls it in 280-68B, I think old age homes, homes for the aged, convalescent, et cetera. So there's no open space component for any of these types of uses. So that second part of this proposed ordinance, 281-15.6, provides for an open space component. So there, if someone comes forward with that type of a use, senior living type of use or similar use, there'd be an open space component. There isn't any such proposals in front of the township. There's been some inquiries, I know, through Kevin Kachansky's office. He and I had talked about some of these uses in the last 2 or 3 weeks. And with the density modification plans that you've been seeing, it made sense if there was going to be an increased open space component for that, it ought to also happen for these other uses. So this is before the board for introduction. This is a zoning amendment. The board approves the introduction. It goes to the Township Planning Commission and the Delaware County Planning Commission. So you're probably looking at about 45 days for this to come back to you for a hearing.
Excellent.
Jack, do we need a motion and a second on this?
We do. I will so move. Is there a second?
Second.
Is there any commissioner comment?
I just
Yeah,
have a
so
couple.
John, so John, basically what this will do will reduce density in the township if you're going for a density modification by adding additional open space requirement. What's the overall goal?
Well, I think the goal of something like this is to provide more usable open space in residential developments, and depending on the tract of ground, there would be some density reduction. But there'd also be increased open space, and it would be usable open space. It wouldn't be, a lot of plans that the township's seen and a lot of townships see open space as basically unusable land or land that can't be built upon anyway, sort of the remnants. So this, has a contiguous requirement. It has a larger percentage which I think is still way below many municipalities, some of which have 50% requirements. So that's it. I mean, it's a general planning goal, Commissioner Booker.
Can I
Well,
ask a question?
Well, in light of that, well, why not have it be 50% then? Why'd you pick 25%?
Well, you're at 15% now. I think that in a more built out community, that's more appropriate. Townships that I'm aware of that are at 50% are probably about 80% farmland and open land. And, started on open space in their zoning a lot earlier than Radnor Township has, and a lot of the, more built out communities.
Do we have to have density modification provisions?
There's no requirement that you have those types of provisions.
It seems antithetical to the density modification provisions, because basically you're saying you can do a density modification and inquire to get more density, but you have to provide more open space, which reduces density. So it seems there's an internal tension in the proposed legislation. And maybe another way to look at this would be to consider whether we need density modification provisions at all.
That's probably something that if you're going to make that kind of a change, you're going to end up rewriting your whole zoning ordinance.
I see Steve shaking his head on that.
Can I ask John a question? So I kept trying to scroll through this on my iPhone, trying to read the ordinance, and it was like page 200, and it kept on disappearing on me. I guess there was a glitch and I couldn't scroll through. So I think this is at 25%. It's 15%. We're going to move it up to 25%. Am I correct on that?
Yes.
Okay. Now let's say we talk and we discuss and we vote on 25%. Could we change it to 35 or 40%, or would that have to go through planning again?
You'd have to go back and start it over again.
Okay. So I like the idea of increasing it, but I think that we should. You're saying that other townships and municipalities go as high as 50%.
Very rural municipalities have 50% open space requirements.
Okay.
Some of it has to be farmland. As soon as you start setting aside land, you have to be careful that it doesn't become a taking. So this is for this community, I think this is a pretty reasonable percentage going forward.
What's the downside to increasing it in a community like this, like Radner? Is there a downside to having it, maybe not 50%, but 40%, 35%? I
don't know how to answer that question.
Okay. But I'll say this, that if we're going to do this, I think 25% is too low. So I would like to see that 35%. So I don't know if I need to make a motion for an amendment to that. But if we're going to do this, we should do it, and we should preserve any, if we're going to redo the ordinance, we should do it with the idea of preservation of open space. And to me, the difference between 15% and 25% it's a lot, but in general, it's minimal. I've said this before. I've said it at our stormwater meeting. We're running out of open space where we have issues of stormwater. This will help it, but let's go far beyond what we need to do. So
Remember that this is not just a change from 15 to 25%, though. This also accepts out items that would have been considered an open space that no longer can be considered an open space, or at least not 100% of it, like stormwater setbacks, that kind of thing. So the practical effect is it's a much more significant increase. And as John has said, there are concerns about takings issues. If we just, I mean, we could make it 100%. We could say from now on, it's going to be 100% open space, but that effectively means that we've taken property and we're going to have to pay somebody in an inverse condemnation.
Well,
So could we
well,
do
that,
30%? On stop. Just 1 second, Rich. Could we do 30%?
yeah. If you want to make that motion, I think that's a good
Yeah,
motion.
yeah. I'll make a motion to raise it from 25 to 30%.
There's a motion. Is there a second?
I'll second.
All in favor, say aye.
Aye.
All opposed, nay? Nay.
So,
Motion
I
fails
guess-
4-3.
Well, we didn't get the nays, but that's fine. I'll remake that motion again next week.
all right, so just hold on 1 second.
Wax on, wax off.
Hold on 1 second. I guess what I would want to understand. So I don't want to set us up. I don't want this to set us up for any sort of, battles with landowners or things like that. I don't think we can be arbitrary about it. Certainly, I would love to see more open space preserved. But I think that, to Jack's point, what we've done with this or tried to do with this is make it so you can't count, your big giant stormwater basin that you have to put on your property as open space. You can't count a grassy, marshy area as your open space. You can't count steep slopes as open space. You need to have real usable open space, in addition to those other things that will not only enhance the look of the properties as well, but also limit the amount of development that can happen on the properties. I guess the thing for me that I've sort of been, churning a little bit is some of these developments that are coming forward and saying like, oh, this is our open space. No one else can use it. It's back in this back corner over here. It's hidden. It's not really doing anything to enhance the property or the design or help inform the design so that it looks better. It's more appealing. I mean, let's face it, right now, a lot of the areas that could potentially be developed within the township are smack dab in the middle of established neighborhoods. So I think the idea to put some sort of parameters, stricter parameters in place to make it so, you're not getting an extremely dense development or losing a lot of open space area in established neighborhoods is going to be something that is desirable. I honestly don't know right now if the right number is 25 or 30. Like I don't know. What I don't want to do though is set us up for issues with property owners, because we need to be able to balance those two things. I think that in the township, and some of this has stemmed from my discussions with Kevin around the 452 South Roberts Road property. We have about 12 zone PI properties in this township. Certainly, we don't anticipate anything happening to a lot of them, but that is something that we have cornered the market on here in Radnor, and we certainly don't want to be facing, I think, a lot of development or changes in big dense developments on some of these properties. So what can we do to help minimize this? And I think this is maybe a first step in trying to do that without making it something that is, a complete, completely constraining those property owners. We can't, we need to balance that as well.
Lisa, so with that said, could we have someone like Steve Norsini or one of our engineers give us maybe a better number? Maybe it is 30%, maybe it's 35%, maybe 25%. Too high, but would you suggest that we go that route to have them dig up some information of what would make the most sense?
Well, I'm willing to go with what our solicitor gave us. I don't think he pulled
Sure,
that
but-
arbitrarily out of thin
No,
air.
no, no, no. Well,
If you
the solicitor's not, you know, he's not an engineer when it comes to stormwater and you know, land use, as maybe Kevin Kuchansky or Steve Orsini is. That's all I'm saying.
But
I'd like to hear what they would have to
I
say
think
about
he-
that.
I am an expert in zoning, Sean. I've actually testified as an expert in zoning. So I've seen a lot of zoning ordinances. I didn't just pick this number out of my ear. You know, it almost doubles what you have on the books. And to Jack's point, if you exclude wetlands and other really unusable land and buffer yards, you're at your 30% in most cases, probably higher.
So, okay, so what are the odds that, you know, that a developer or an institution will come in and then just go for a zoning variance by saying it's a hardship? Because we've seen that in the past.
They would have no legal grounds for that. I mean, it doesn't mean they wouldn't do it, but the town.
They do it all the time. That's, you know.
Well, yeah, but you can't get a use variance. I mean, there is no hardship. If this is on the books, you know, sure, anybody can go to the zoning hearing board. You can't stop people from going to the zoning hearing board if they want to roll the dice. But this has got to go through a planning process. And if the planners and the county think that 25% is not the appropriate number, let's let them make that recommendation. I looked at a lot of different ordinances, different communities, similar communities. And, you know, that, in my opinion, the number makes sense to me, given the other restrictions that are being added to that paragraph.
Okay, I would just like to hear what the engineer, if the engineer had input. If the engineer's fine with your numbers, that's fine. I'm looking at other larger things. Maybe there's golf courses or other, you know, other large tracts of land that could possibly come up. So yeah, but I definitely think that this is definitely the step in the right direction. So I don't have any problems with that, but if we're going to do it, let's do it and save as much open space as we can for our residents and for the quality of life in Radnor.
I agree with what Sean is saying and just would push on the 25% as well. Remember, it won't be a taking. I can't see how this would be a taking because this only applies under density modification. If you're seeking a use variance under a density modification, then the density modification has an open space requirement. It's not a taking because it's not a rule of general applicability. So I think that the people to set what the percentage is right here, not the planning commission. It would be up to us, and the planning commission could say, no, that's out of line. It's too high. But this would be the place I think that we should, if we want it to be more, that we should put in a bigger number and then see if others have comments on it.
Density modifications are by right uses as long as you meet the requirements.
Well, we just established a density modification is not necessary to have in the ordinance at all.
But as long as we've got them, they're by right use as long as you meet the requirements.
So raise them.
When we pass this to planning, can't we pass it to planning with the idea that we're at 25%? And if planning says go for 30, can't they send it back to us with that?
Would we send it to them with that instruction to ascertain whether that's the appropriate level? I mean, I think all of us agree we want to save the open space as much as we possibly can. My concern is that if we pick a number that is sort of too high or outrageous, you know, we may be opening that up to a challenge. So I'd like to get it right. I'd like to balance the interest of the landowner with the interest of the entire community to preserve open space and reduce density.
So we would have planning commission, this will go before planning commission, as a solicitor noted, looking for a recommendation. And if there is a recommendation, they can always put with the condition that it be at X percentage. We'll get something from the planning commission either way. So that's not a problem, is what I'm saying.
Is there any additional commissioner comment? Is there any staff comment? Is there any public comment? I don't see any hands, so I will call the vote. All in favor, say aye. Aye.
Aye.
All opposed, nay. Introduction passes unanimously. Moving on to item 4, reports of standing committees of the board. Do we have any reports? Hearing none, moving to item 5. Do we have any new business?
Can I just mention, since we were talking about South Roberts, 452 South Roberts Road, so there is going to be a Zoom meeting tomorrow night from 5 to 6. I want to thank Mr. Norsini, Mr. White, Mr. Kachansky, and Mr. Rice, who will be joining in that meeting. It is mainly for the residents, and I will tell you in the past 2 days, I've heard from more and more residents who are interested in knowing and understanding what's happening at the property. It really is just to give people the information about what it's currently zoned and what could potentially happen there, and what that process would be if somebody wanted to come in and change the zoning, what that would look like. But the majority of the meeting is really, from my perspective, to hear from the neighbors. What are people interested in over there? What are people concerned about? What are they, for lack of something better to say, willing to tolerate over there when it comes to development? I know we've had a number of developers reach out to various, township representatives as well as commissioners. We've been sharing the Zoom link for them to get on there. So there'll probably also be some developers on there as well. My position has been to anyone who's reached out to me, get on, because what is going to really weigh heavily into my consideration for anything on a final vote that would come before this board is what the neighbors are interested in. So that is tomorrow night at 5 o'clock. There is the Zoom link can be found on the township website. So thank you to Molly and Ian for getting that going. It will be from 5 to 6. We're really going to keep it to an hour. Because John has to leave and I also have to leave for something else. So yes, so anyone is welcome to join and please do.
Great. Do we have any additional new business?
Yep, Jack, two items for Bill. Bill, just to clarify, are all subcommittee meetings using the new Zoom format?
Off the top of my head, I'm not sure. They have access to it. Ian, I'm not sure if I put you on the spot, if you know that off the top of your head.
We are transitioning all the subcommittees over to the webinar format. Yes.
Okay. All right. That's good to know and good for residents to know. And then my understanding is some neighbors are getting letters regarding development at 250 King of Prussia Road, but there's nothing on the website regarding this that I'm aware of. Can you shed any light on this issue?
No, Commissioner, let me look into that and get back to the group. Off the top of my head, I'm not 100% sure. Unless
so
chopping at the bit.
We're that'll go up in about a week. We have to get everything ready from the applicant to post. So I will shoot that to you and the manager as soon as we have everything.
And to me, Steve. I haven't heard anything about it.
Absolutely. So there's King of Prussia Road has 2 areas in play. The old Penn Medicine purchased by Brandywine Realty Trust and the other half of the Penn Medicine site that was previously approved land development for hotel, office, and parking.
Okay. Do we have any old business? I have one item, actually going back to just earlier in the meeting. I think that I called item F, resolution number 2021-22 as a unanimous vote I think that that should have been 6-0 with Commissioner Abel abstaining. Is that correct, Jake?
Correct, I did recuse.
Excellent. Okay, so that, to the extent I got it wrong before, it should be 6-0, not 7-0.
Thanks,
Is
Jack.
there any more? Thank you. Is there any additional old business? Hearing none, I will move to public participation. Is there anything that we can hear from the public? Mr. Brunn, I see your hand up. You are free to talk.
Hi, can you hear me?
Yes, I'm sorry, I said Mr. I just see the D.
Okay, sorry. I don't know what was happening before that couldn't go through. I just wanted to add something to what you were talking about with the cell towers in the neighborhoods.
Can we get a name and address, please? Can you
I
introduce
live
yourself?
actually in Cape Cod, but my mother lives on Malin Road and has a cell phone tower right smack in the front of her lawn. And so I'm one of those people that Lisa referred to in her township on behalf of my mother that is super concerned. And I have recently done, I want to say upwards of 100 hours of research on RF radiation. And it's a really, really serious problem. So I just felt like I needed to put some color to what you're talking about. I think it's important to recognize, in my opinion, that this extends far beyond whose responsibility it is and what kind of litigation is going to happen and the town's responsibility. There are towns and states and countries all over the world that are coming up with policies to protect their citizens. And there's a lot of precedent for that. If you do even the tiniest bit of research, you can see, policies like Los Altos, California has mandated that you cannot put cell phone towers on people's residential properties or in residential properties, and they have to be 500 feet from schools or multifamily dwellings. So I think this is going to end up like the tobacco industry versus human health. And I feel like certainly as a township, but as a people, we should come down on the right side of history on this one. So I don't think it's simply a matter of what's expedient, and the Supreme Court won't stand in the way of some of the things that the townships can actually do. So I would recommend I'll send to public comment some research that some of the neighbors have done. We had a building biologist come out, we had the cell phone tower people come out, but in short, at least 2 houses on those roads have no place in their homes where they can escape radiation because of those towers. So they can't rest and repair when they sleep. They are constantly being radiated. And right now, there's probably not an easy legal pathway for residents, but at some point there will be. I mean, I think it's a pretty tight analogy to the tobacco industry issue, where your doctor smoked, your neighbor smoked, everybody smoked, and now everybody knows the health hazards with smoking. I think it will be very similar with RF radiation, only at least adults could choose whether or not to smoke. And my mom cannot choose not to have a cell tower on the front of her lawn. I mean, if you do even a modicum of research, the outrageousness that is even happening, that no one notified, if, one day it was there, one day it wasn't. So that's what you're looking at in Newtown Square and, larger parts of the township and even in Pennsylvania. And, other municipalities, states, and countries have taken the initiative to put into place policies to keep this from happening in places where people are aware of the dangers of this. And I think it would be really important if you all would be proactive in that way, not just find out what the lawyers say you can and can't do. If we find out the township is getting paid for that cell phone tower, I live in Cape Cod, and the only way you can get a cell phone tower put anywhere is if the person under it is getting paid quite a bit of money.
And you have 1 minute.
That's all I wanted to say. If it does turn out the township is getting paid for that, that's a serious issue. But I hope that you will get on the right side of history on this one, and I appreciate you listening. Thanks.
Great, thank you. Is there any additional public participation? Seeing none, I will call to adjourn. Is there a second?
Second.
All in favor, say aye.
Aye.
Aye. All opposed, nay. Motion passes unanimously. Thank you all. This concludes the meeting.